I'm Sonam Naruker, and on behalf of the Food and Agricultural Law Society, we are proud to introduce the Information Disclosure Through Food and Product Labeling panel, and our moderator, Professor Lori Baranavan. Professor Baranavan, who is the Assistant Director of the Center for Food and Agriculture Systems. So please give a warm welcome to our panel and Professor Baranavan.
Thanks so much. So, despite the fact that we have such a great, distinguished panel, I'm going to keep their introductions relatively short so that you get to hear from them and less from me. And there are also much longer introductions of everyone in the brochure that you all have. So, our first speaker is DeLorme. She is an attorney with the Federal Trade Commission in the Division of Advertising Practices. Our next speaker is Brian Dunkiel. He is one of the co-founders of the firm in Burlington, Vermont, Dunkiel Saunders. Our third speaker is George Kimbrell. He is a senior attorney for the Center of Food Safety. Our fourth speaker is Walter Olson, who is a senior fellow at the Cato Institute Center for Constitutional Studies. And our final speaker is David Zuckerman, a Vermont State Senator and a farmer at Full Moon Farm. Oh, Christine, would like to start.
Good afternoon. I'm just going to give you a brief overview of sort of what the FTC is doing in food labeling and food advertising and what our authority is and what are the limits of what we can do. And let me start out by saying at the FTC, we love disclosures. We believe that, consumers having access to full and accurate information is the best way to make sure that they make fully informed decisions, and that having more information available provides the right incentives for manufacturers and advertisers to develop better products that have the characteristics that consumers want. In fact, we do have a lot of industry-specific laws requiring disclosures. For instance, if you make funeral arrangements, the FTC has a rule that you have to get a price list of caskets before they show you any caskets. We have rules that if you have a website directed at children under 13, you must post a privacy policy. We have a rule that you have to post the octane rating of the gasoline at the gasoline pump. So there are many instances in which we have mandated disclosures. Oh, and my very important disclosure, everything I'm about to say is my own personal view and not that of the FTC or any individual commissioner. So, for those of you who don't know, the FTC has a dual mission. We do both competition law and consumer protection law. So the portion I've highlighted in blue is the authority we use for consumer protection, and that is our ability to challenge unfair or deceptive acts or practices. And when I say deception, that sort of goes back to the part of my title that said the whole truth. You can't lie to consumers. That's basically what that comes down to. And that's in our FTC Act Section 5. With regard to food labeling, we also have a portion of our statute, Section 12, which was promulgated in 1938, which specifically gave us the authority to regulate false advertising for foods, drugs, devices, and cosmetics. So Congress apparently had in mind that this was an area that needed specific attention. So we do, in fact, have a very rich history of doing a lot of enforcement actions in food, dietary supplements, and cosmetics and OTC drugs. We don't handle prescription drugs, by the way. So in case you're wondering how we relate to the FDA, because obviously they're very involved in food advertising and labeling, under a 1971 Memorandum of Understanding, the FTC has primary jurisdiction over advertising for foods, dietary supplements, over-the-counter drugs, and the FDA has primary jurisdiction for labeling. So Lori had asked me, what's the difference between advertising and labeling? All labeling is a subset of advertising. So we consider advertising to be absolutely anything you use to promote your product. It can be on the label, it can be a traditional ad like a radio ad, television ad, magazine ad, it can be your website, it can be what, if you have a sell over the phone, it can be whatever the salesperson says over the phone to you. It can be a pamphlet that's inserted, it can even be a book in some cases. That being said, we do bring enforcement actions relating to food labeling, because as I said, we consider all labeling to be advertising. And in 1994, we put out a very extensive policy statement explaining how we were going to approach labeling claims on food, especially with regard to the FDA policy. And we put this out after the Nutrition and Labeling Education Act in 1994, just to clarify how we were going to interpret that. And I'm not going to go over this, but the statement is available on our website. It's very detailed. It explains how we're going to look at nutrient content claims, things like this food is low fat, or this food has more vitamin C than our competitor, or this food, may prevent cancer. It's very detailed. But the main point I want to get across today is that in our enforcement policy statement, we are very clear that we want to be consistent with the FDA. So it actually says, this is almost verbatim, that we will harmonize our enforcement program with the FDA's food labeling regulations to the fullest extent possible under our statute. We recognize the scientific expertise of the FDA. The FTC does not have any scientists on the payroll, unlike the FDA, which actually has physicians and scientists who are there evaluating claims. The policy says we will accord their determinations great weight, and we will continue to do so, and that it is very unlikely, but not impossible, that we would bring a deceptive advertising case in a situation where an advertiser's label comports with all the relevant FDA regulations. In fact, it's sort of the opposite. If anything, the statement indicates that FTC law is a bit more flexible. The FTDA regulations are extremely specific and regimented, right? If you want to say your food contains a nutrient, it has to have a certain percentage. If you want to say it's a good source. So our regulations actually point out in several places where you would be a little more flexible, and that there may be claims that are permissible under the FTC Act that are not permissible under FDA regulations for labeling. So what makes a claim deceptive? There's a three-part test. One is you have to make the claim, and actually there's often a lot of debate over whether or not an advertiser or a label makes a specific claim, because we consider what we call the net impression of the claim. We look at everything, the graphics, the whole package, not just, the FDA is a little more formalistic, like you must have this exact phrase using these exact words, and we interpret everything as a whole. There are a lot of implied claims that we take away. It has to be viewed from the perspective of a consumer acting reasonably, but there may be more than one possible interpretation of a claim, and if so, the advertiser is responsible for all of them. It has to be about something material. In other words, something that would influence the consumer's decision to purchase, and we would consider all health and safety claims to be material. You don't have to have intent to deceive. When I say that you can't lie, what do you have to support your claims? You have to have competent, reliable scientific evidence. So that includes if you're saying your food has X grams or milligrams of this vitamin or this nutrient, you have to have some reasonable basis for that, some scientific evidence. If you want to say this food has been clinically shown to reduce the risk of stroke or whatever, you have to have what normally we would say would be randomized controlled studies. It's a rigorous but flexible standard, and with regard to food claims, in many ways it's similar to the FDA's significant scientific agreement standard. Now here we get to the part about half-truths. So before I said you have to tell the whole truth. So if you say this food prevents colds and that's not true, that's obviously just a flat-out lie. But oftentimes advertisers may say a half-truth, which requires a disclosure to cure it. So deception can occur through the omission of information that's necessary to prevent something else you say from being misleading. For instance, let's say that you have a food that's low in sodium. So you say this is a low sodium food, and it's been shown that low sodium diets may reduce the risk of heart disease. But let's say that food also has very high levels of saturated fat. So that sort of tips the scale the other way. We would say that claiming that food is low sodium for the heart benefit would be deceptive because you haven't said the other half about the saturated fat. So that's a half-truth that requires the rest of the truth in order to cure the deception. If you just remain silent, it can also be deceptive if there are circumstances that would make your silence deceptive. But not all omissions are deceptive, even if the information would be helpful. So for instance, a few years ago we got a petition from Compassion Over Killing asking us to enact a regulation for eggs, saying that all eggs should either be labeled free range, cage-free, or caged. Now, there are a lot of consumers who would love to know this information about their eggs. It may matter to them. But one, it's not within our authority to do a labeling role there. But even if it was, not every single piece of information that would be useful or beneficial to consumers is going to be mandated through a law. If you make some sort of disclosure, we look at what we call the 4 Ps to see how effective it is. Is it prominent? How is it presented? Where is it placed? Is it in close proximity? And one important thing to remember about disclosures and disclaimers is disclosures cannot contradict other things that you've said. They can clarify them, but you can't make a claim that's false and then have a disclosure that says, and by the way, not really, and then expect it to cure the deception. Our options for what we can do at the FTC to police deceptive claims, we can have formal law enforcement actions, we can file lawsuits in federal court in our own name or administratively. We can issue warning letters, which is sort of a please pay attention to us. You've done something wrong, we would like you to correct it. A closing letter, which is where we've done an investigation and usually the advertiser has agreed to stop the practice, and we will publish a letter on our website available to the public saying, they've explaining what the situation was. So it's more educational. So for instance, we issued one to, I think, Salmon of the Americas, where they had a claim saying that pregnant women should eat salmon because, of the omega-3s, and there was no disclosure about, by the way, you should not eat salmon if you're pregnant because it has all this mercury in it. So there's a public closing letter. We have informal outreach. We actually do a lot of things like this, but also we go to trade shows, like natural foods trade shows, and we walk around the floor and we talk to manufacturers and look at their claims and say, hey, have you thought about this? Or do you have any support for this? Or I've actually just seen things in the supermarket and called up the manufacturer and asked them if they would change their labeling. And actually this has worked. We do consumer and business education, and we do a lot of workshops, reports, and studies. For instance, we recently did a big study on food marketing to children. We have the ability to issue subpoenas to get companies to tell us information. Rulemaking. So I mentioned earlier that we did have a lot of rules, like about, funerals and so forth. We do not have the ability, as of 1975, to do general APA rulemaking like the FDA. So we have done a lot of rulemaking since then, but it's all when Congress has specifically directed us to enact a rule. So we do not do any rules in the last 40 years unless Congress has specifically directed us to do so. So for instance, when I said about the eggs, we would not have the ability to just enact a rule saying it's deceptive if you don't say your eggs are free range. And then this is just, a quick overview. We do a lot. I love my job because we work with consumer products everybody knows about. So just a quick overview, we've done some recent actions dealing with pomegranate juice, dealing with Activia, KFC, Tropicana orange juice, Wonder Bread, Stouffer's, Kraft cheese. That's actually a big seminal case in FTC law. We do a lot of food enforcement actions. And I think we do play a valuable role. We fill a gap where the FDA, hasn't really gone. They're really concerned more with the labeling, and we do, an important function in making sure that the advertising is good on the back end. We don't do any pre-approvals, but we just catch the advertising once it's already out there. So that's it.
Thank you. And I often answer clients when they say, well, are we going to get caught for this claim? I say, well, do you want to plan for or accept the risk of, what if there's an FTC enforcement attorney just walking through the grocery store and sees this claim? Or do you want to plan another way? So I'm glad that's no longer a hypothetical. And it's really just reflecting on the exercise of thinking what to say to this group today. It was really refreshing not to be confined to the rules of civil procedure in my thinking. And with this liberation, of not having to provide answers to all the problems. Really, all I have to leave you with is questions. So this is the only image I need. And this image basically demonstrates that there has been no new command and control environmental laws passed by Congress since 1990. And that fact, along with some stats that I'm going to explain, made me start to think whether or not the consumer is the new regulator. And so the title of my talk is Whether the Consumer is the New Regulator. As I thought more about what I'm going to talk about, I would have renamed it to say, uh-oh, what if the consumer is the new regulator? So, consumers want more green products. And in many cases, even during the recent recession, consumers polled indicated that they're willing to pay more for green products that work. Sales in the product category known as healthy products and healthy planet grew between 2004 and 2012 from $587 billion to $771 billion. And in 2014, they're forecasted to grow to $831 billion. 35% of those polled said that they would pay more for green products that work. And in 2013, a survey by Green America of 1,300 businesses found that the greener the product was, the more likely its sales increased. And the study also found in the deep green product segments, those sales increased the most. So, to meet consumer demand, we see large and small household cleaner manufacturers like Clorox and Procter & Gamble and Method and Seventh Generation continuing to develop more non-toxic and plant-based products. And as an example of that, within about 6 months ago, Procter & Gamble announced that they were going to remove triclosan from all of their dish soaps. So, I think it's safe to assume that the markets are doing something, but what are the consumers basing their choices on? And that is, in general, marketing claims. So what sort of marketing claims are we talking about? And here are some examples that I'm sure you're definitely familiar with, but I'm sure many of you are also. No VOCs, non-toxic, chlorine-free, recyclable, carbon neutral, biodegradable, a slew of certifications. I think that there's over 170 certifications in the marketplace right now. And then my favorite, and probably yours, environmentally friendly. So we should ask, if the consumers are a key component to drive environmental innovation and improvement, what is the role of the regulators that protect consumers from marketing deception as they are, intentionally or not, setting environmental policy? And I just apologize in advance for these comments. So the FTC is the federal agency charged with consumer protection, and it administers the Federal Trade Act, which prohibits claims that are likely to mislead the reasonable consumer. However, the FTC frequently reminds us that it has no environmental mandate when administering the Federal Trade Act. For example, in the recent Green Guide updates, when evaluating claims about climate change, the FTC explained it does, as it declined to opine on a critical issue concerning climate change, that, quote, more detailed guidance would put the FTC in the inappropriate role of setting environmental policy, thus leaving marketers with no guidance on that issue. The FTC Green Guides consider almost exclusively the consumer interpretation of claims. A claim can even be deceptive and in violation of the Federal Trade Act, even if it's scientifically and technically accurate. So where does that leave us? Consumers can drive environmental innovation, consumers can make decisions based on claims, But the agency that protects consumers from deceptive environmental claims is agnostic on environmental policy and can apparently disregard environmental science. Not that it does that often. For me, it raises several critical questions, and here are a few of them. We should ask ourselves, is the consumer power a good thing for protecting the environment and human health? Or, in other words, will consumer demand translate into cleaner air, cleaner water, or habitat protection? Another question, how does relying on the consumer to spur innovation and change compare to ordinary policies that mandate it? So, for example, a positive of using the power of the consumer is that it does not necessarily observe political boundaries. When Walmart says, you will set a certain standard, or we will only have on our shelves a product certified in the following ways, that influences what manufacturers are doing globally. And the federal government can't do that in many instances. On the other hand, the federal government, at least when it passed regulations in 1990 and before, often charged agencies to use sound science in making its rules. So, for example, in the Clean Air Act, air quality standards, as you probably are aware, are set based on using the best available science about protecting human health and the environment. So, depending on how you respond to those two questions, it kind of poses, for me, this last question, which is, should the FTC have an environmental mandate? Thank you.
Well, good afternoon. I want to thank the law school for inviting me to be here, and it's an honor to be on this distinguished panel. Thanks for joining us. Our organization, Center for Food Safety, we're what I like to call a sustainable agriculture nonprofit. So we work on the intersection of food and the environment, and I wear a number of hats in doing that. Part of it is kind of the environmental impacts of agriculture, and part of it is your right to know. And today I think my talk, the topic that I've been assigned, is kind of a microcosm of this symposium, which is the constitutionality of state labeling of genetically engineered foods. So I'll harken back to the motif from this morning. Raise your hand if you think you have a right to know that your food is genetically engineered. Raise your hand if you don't think you have a right to know. Okay, well that's about what polls show. Basically, polls repeatedly show 90 to 95% of U.S. citizens believe that we should have labeling of genetically engineered foods. So you guys are right on there with the majority of Americans, and in fact the majority of the world, since 64 other countries require this type of labeling. We've been working on this issue at a federal and state level for about 2 decades now. And to that end, we've worked kind of with dozens of states on the crafting of legislative initiatives and ballot initiatives, including California's Prop 37, which I co-authored, and then the recent Washington I-522 that's going to be voted on in November of this year that I also co-authored. And my job is to make sure these laws are well crafted and are going to pass muster when they're challenged in court, because we know they will be. So this is a complicated topic, and in the few minutes I have here, I'm going to be very succinct and kind of summarize the main legal issues. And those of you on the Vermont Law Review are going to be the leading experts, I'd say, in academia pretty soon on this, since you're going to have Professor Murphy's article and then my article on this. So you're going to be in the weeds here. And I want to commend Vermont on their work on this topic. For a long time, as I was looking at a lot of these thorny legal issues about if states could do this and labeling of genetically engineered foods, we were kind of alone on it. And in recent years, it's been just amazing to be able to talk with Laura and others here and about this topic and their work on it. So there are 3 major areas I think that essentially come into play when you talk about this. Preemption, First Amendment commercial speech, and dormant commerce clause. So I'm going to talk about those a little bit, each of those. And then I want to talk about two new cases, literally, that just came out in the last couple of weeks that I think are really important cases with regards to labeling. Not on genetically engineered food labeling, obviously, but analogous cases that I think are important ones. So first, with regards to preemption, obviously, we know that that federal law will supersede state law when there is a conflict, when there is express or implied preemption. There's different ways it can happen. It's important to note that when we talk about food labeling, we're talking about an area that's historically one of state regulation, so that you start with this kind of presumption against preemption. And I start with preemption on purpose because I think that it's important to note at the outset, and again, this is kind of one of the, I think, themes of the conference here, is kind of this question of whether we have regulation or we have labeling, and is labeling a substitute for regulation. Well, when you talk about genetically engineered crops, and as somebody who's litigated this for 10 years, I can tell you from experience and lost hair, we don't do a very good job regulating genetically engineered crops in this country. And so what that means for labeling, though, is that there's not going to be a hard law source of preemption from a federal perspective, and so there's going to be room for states to operate. Specifically on labeling, FDA only has a policy statement, essentially. There's not a statute, there's not a regulation even, there's just a policy which can't have preemptive effect. So that's the specific to, let me be perfectly crystal clear, we have no laws in this country that are directed specifically at the regulation or labeling of genetically engineered foods or crops. Second, more generally, when it comes to food labeling, the main statute is, already been mentioned, the Nutrition Labeling Education Act of 1990. Now there is an express preemption provision in it, but it's limited to just those categories that are expressly preempted, and there is therefore no implied preemption. And the process of genetic engineering is simply not one that is listed there, so there's not going to be any preemption from there either. So that's the 10,000-foot overview on preemption. And we don't really have to worry about kind of this debate between regulation and labeling. I think I'll come back to it at the end, but I think labeling will help us move towards better regulation in this arena. On commercial speech, I think the take-home is that states can compel foods produced through genetic engineering because it's a factual disclosure that is reasonably related to legitimate state interests. Okay, and we've got a myriad of state interests that kind of show this, and they're basically three different categories, at least: health, environment, and economic. So, for example, let's say a state, say Vermont, wanted to require the labeling of genetically engineered foods. There is an interest that is meaningful for Vermont there in preventing consumer confusion and deception by disclosing the fact of production of genetic engineering about which consumers rightly have health and safety concerns. And they have those concerns not because we know that genetically engineered foods are harmful for your health. We don't. But I think that's kind of a misframing of the issue. We don't label foods that we know to be harmful for our health. We take them off the market shelves. Consumers have concerns about them because FDA itself provides no independent oversight of them. They make no regulatory decision of their safety. They have a voluntary meeting with industry in which they kind of rubber stamp the industry's determination of safety. And even that is a confidential meeting, and even that one is voluntary. They don't look at the hard data that the industry has produced, only summaries of it. I think that in and of itself, that lack of adequate oversight at a federal level from a health perspective provides an interest at a state level for consumers of Vermont or any state to require labeling. Economics. A given state's, Vermont, say, citizens should have the choice to avoid purchasing foods if their production could harm their local economy. Now, when you talk about genetically engineered crops, they're very promiscuous. They contaminate conventional and organic crops in many different ways, causing economic harm to farmers and businesses. And David, I'm sure, can speak more to that, being on the ground about it. You look at our export markets, you've got 64 other countries that we deal with that require labeling and or regulation of these crops. And where I live in the Pacific Northwest, we've recently had two different transgenic contamination incidences, one in wheat and one in alfalfa, that have caused great economic harm to farmers and exporters. So identification, labeling, is a critical method of preserving those domestic and export markets that are sensitive to contamination. And then on the environmental side, it's essentially, there's a lot of myths about these crops, but the reality of them is that they are an unsustainable way of producing food. After 2 decades of research and commercialization, we're left with about 85% of them that are really good at one thing, which is being resistant to herbicides. It's kind of a one-trick pony in that regard. So they've massively increased the overall herbicide into our environment. So again, this is something a state has a significant interest in avoiding. Consumers want to know about, reason to label. So those are just 3. There's others that give states much more than the mere rational basis that's required here to require labeling, and overcome any minimal interest the food companies have in not disclosing this information. And then the final area is kind of that labeling would be in harmony with the Dormant Commerce Clause. And then here, you have basically Dormant Commerce Clause law that Congress at a federal level regulates interstate commerce, and states can't discriminate against other states, essentially, facially or implicitly. Well, state law that's going to require this type of labeling and limit it in state is not going to be facially discriminatory. So you're going to go to the second step called the Pike test with regards to whether it implicitly discriminates or not against interstate commerce. And there the test is essentially the law will be held to be proper unless the burden it imposes is, quote, clearly excessive in relation to its local benefits. So we've already talked a little bit about the merit of benefits locally from labeling, health, economic, and environmental, and I think it's a far cry from clearly excessive. So any inconvenience of labeling would be a far cry from clearly excessive. And courts have repeatedly held these types of benefits to be sufficient, importantly, in other contexts. How am I doing on time, Laurie? Almost over? Okay, all right. Well, I'll go to the end here. I've got a couple of cases I wanted to mention specifically that just came out, as I mentioned, that are on point. One is with regards to the Dormant Commerce Clause, it's called Rocky Mountain Farmers Union. It's a Ninth Circuit case from the 18th of this month that was just issued on the California Air Resources Board low carbon fuel standards regulation of ethanol. The district court has struck it down, and the Ninth Circuit on appeal reversed and sent it back and said it wasn't facially discriminatory under the Dormant Commerce Clause. Judge Gould, I'm proud to say, who I clerked for, was the author of that opinion. And he said, it has been sagely observed by Justice Jackson that the Constitutional Bill of Rights is not a suicide pact, nor is the Dormant Commerce Clause a blindfold. It does not invalidate strict scrutiny state laws or regulations that incorporate state boundaries for good and non-discriminatory reason. It does not require reality be ignored in lawmaking. So I just think it's going to be a good Dormant Commerce Clause case that it's going to allow states to take regulatory action, both in labeling and other arenas, in addition to obviously helping on the climate change front. The second one is more specific to food labeling, and it's the country of origin labeling case. Some of you might have seen this decision. This is a district court decision from September 11th of this year. This is a challenge by the American Meat Institute to USDA's regulations implementing the cool regulations. And it was a motion for a preliminary injunction that the district judge denied, essentially here saying that so what was required to be labeled was meat production steps, labels for cuts of meat to specify where each production step took place, okay? So it's a production step disclosure requirement. Sound familiar? Sounds familiar to me. Just like genetic engineering, another production disclosure requirement. Second, the district court there held that the test I described earlier, factual disclosures, the Zuruder test, applies here rather than the Central Hudson test, which is an intermediate scrutiny test, a little bit more difficult to meet. And that even though USDA hadn't included any findings in the cool rulemaking with regards to why it was doing this, the court said it had met the requisite showing here because, quote, common sense demonstrates the compelled disclosure of production steps targets misleading speech and consumer confusion, and that this was, quote, a purely factual disclosure where an animal was born, raised, and slaughtered satisfies the prerequisites of Zuruder's application, unquote. So, and then finally, the court held against the arguments of the American Meat Institute with regards to the burden they claimed on their finances, and the court said that they had confused the labeling burden with their financial burden. saying that when we talk about limits on commercial speech, we're only talking about burden on speech, not on pocketbook. So I think that's important because we're definitely facing that in the battle to label genetically engineered foods a lot. That is the other side saying that it's going to be costly to label it and so forth. So in closing, I guess my take home, I already mentioned one. I don't think this is kind of an either-or labeling or regulation situation because we really have a void in we have a regulatory system for these crops that is wholly inadequate, and I think labeling will help us move to improve that. And second, earlier, we talked about other contexts where maybe industry was not opposed to transparency and disclosure and labeling. Well, in my world, in my experience, they have been very opposed to it, to the tune of, in California on Prop 37, they spent $48 million there to win, for us to lose that ballot initiative, barely 51 to 49. And now in Washington, they've already spent $12 million, which is the most ever that's been spent on a ballot initiative in Washington. And we still have 6 weeks to go or something. So why are they opposed to transparency and labeling? And I think the answer to that is that they know that their products provide no benefit to consumers or to farmers, only risks. The ones I've spoken about, the environmental impacts of them, the health unknowns, economic hardships. So they want to sell more of their products. I don't think it's a business plan to run away from what you're selling. And that's a big problem, and that's why I think it's not a matter of if we're going to have state genetically engineered labeling, it's just a matter of when, because it's happening. Thank you.
Well, thank you. It would be hard to find a more highly regarded judge or legal academic than Richard Posner of Chicago. So there was a little flurry of press interest a couple of years ago when Posner remarked casually at a public appearance that he had, I guess, recently been through a home mortgage refinance himself, and of course he didn't read all of those forms. And when the press got interested in this, they began asking other figures, and before long, Chief Justice John Roberts was before a podium, and someone asked him, and this was in Buffalo, and Chief Justice Roberts, when you click through for software and it says, I approve, do you read what you're approving? And the Chief Justice said, of course I don't. Who does? So the theme of my talk is, in a few minutes, 5 train wrecks of information disclosure law, and I would submit that the first train wreck you get is if no one is reading the things, expensively drafted by lawyers though they were. If they are presented in a setting such as a mortgage closing in which no one I've ever heard of has been known to stand up and walk away from the table and not refinance their mortgage because they saw something in the fine print, that may not be the occasion for that 150 pages of initialing. The original rationale, as we know, was that more disclosure would keep people out of bad mortgages. And I pause as a laugh line there. And it's because it's so obviously flopped at its affirmative objectives as well as causing the negative ones that there has been such a rethinking in consumer finance regulation of how to do disclosures better, one of the topics that the new federal agency is looking at. So there is a whole literature on how disclosure fails. It's had a couple of very interesting survey articles in the last couple of years. 2 years ago in the University of Pennsylvania Law Review, Amri Ben-Shahar of Chicago and Carl Schneider of Michigan wrote a piece called The Failure of Mandated Disclosure. Slight overstatement in a title because they don't prove that it all fails, but it's a remarkable catalog of how many different ways mandated disclosure can fail. And then last year in the Journal of Public Policy and Marketing, put out by the American Marketing Association, Keston Green, University of South Australia, and J. Scott Armstrong of the Wharton School had a shorter but no less interesting article summing up 15 or 20 empirical studies about whether or not mandatory disclosure programs met their objectives, and concluding that they always fell short, although by how much is varied from case to case. So some of what I have to say tracks those articles, and some of it is new to me. The second train wreck I would mention has come up in earlier sessions, which is what I believe Professor Hemingway called the TMI disclosure, too much information, the overgrown disclosure symbolized by the patient package insert. And if you have gotten a birth control pill or many, many other types of complicated, important medication, you may have unfolded and then unfolded again and then unfolded again and unfolded again the package insert and realized, and the tragedy of the second one, which differs from the first, is that people actually do want to read a lot of the second kind of disclosure because it's actually important stuff. And the process, however, at the drug companies, all of those disclosures started out smaller, and then the lawyers came back for another round. They heard that someone had been sued over this claimed side effect, which was so rare that you'd never heard of it before, and someone else was claiming failure to warn over that, and with very little cost except the ink of adding the language, and no one arguing against putting it in. The warnings grew and grew and grew to the point where some drug companies warn of imaginary side effects, which their own scientists believed had never been caused by their drug, but after all, it might fend off someone's lawsuit. The medical tragedy from this, of course, is that an optimal warning would get sometimes 3 or 4 major points across that you really do need to know if you're using this drug. If we're lucky, those will be the top 3 or 4, but we can't count on them. They could be buried further down. Now, you might think that this is just in areas like pharmaceuticals or product warnings that are heavily driven by litigation, because believe me, the patient package inserts are heavily driven not so much by the FDA pressuring them as by their attempts to beat tort litigation. However, Ben-Shahar and Schneider in their article point out that you find the same gradual overgrowth of the underbrush in areas that are not so much litigation driven. They cite examples like university institutional review boards in which in order to do research you have to get the forms for informed consent approved, and in medical research, more recently with HIPAA having been passed, you've got the process by which the nurses send out to consent you. That's now become a transitive verb. They will consent you probably just before you're wheeled in for the surgery. And again, I've never heard of anyone not going into the surgery for failing to be consented. But studies have found of those informed consents that they too grow, and there's actually a rate at which they grow, which is at 1.5 pages per decade. Apparently, when the IRB program started out, 30 years or so ago, many of the informed consents were like 1/3 of a page or 1/2 a page long, and those same sorts of research now have a 4.5 page consent. So I will say that food labeling is one area that has not apparently on the surface fallen into this particular pit. You look at nutrition facts or you look at ingredient labeling, and actually it's widely cited in the literature as doing a better job than many of these other areas. Now, the question I would ask is this because the food regulators have been more sensible, or just because maybe we're earlier in the process of food label regulation, and after we pack in a few dozen things like production step disclosure requirements for meat, future food in the supermarket will come bell-tagged with little package inserts itself, which you can take home and unfold the way you do with the drugs. I don't know the answer to that. Train wreck number 3 comes about again and again because consumers don't actually want some things that regulators want them to want or expect them to want. And there was one horrifying story of the Federal Park Service, I guess, or Forest Service, which was facing thefts of petrified wood from the West. And so they put up signs explaining what a bad social problem that was and what a disservice you were doing to science by stealing petrified wood in this area. Well, the thefts nearly tripled once people realized that it was something worth stealing in the vicinity. And marketers, believe me, marketers know this so much. I mean, it goes all the way back to the days when publishers would try to get their books prosecuted for indecency because they knew that the sales would go up. It was discovered in the video industry that when they began slapping warning violent content labels, the sales would rise of those games. And It is found in area after area, but particularly where there is sin, where there's the sense that someone's trying to keep you from getting this thing. For example, a study has found that diet drugs, when a warning is added saying that this diet drug may actually be quite damaging to your health, people rate its efficacy better. They say, oh, that must be one of the good ones. People are more willing to consume it because of the safety warning. Somewhat parallel, when phosphates were banned in detergent, there were some marketing studies, and it was found that after people had learned that these were environmentally quite injurious, they began rating better their cleaning power, figuring they must be powerful. And this one turns up particularly often in the food area, which is so interrelated with the concept of sin. Alcohol marketers, for example, and the BATF knows this perfectly well, alcohol marketers would love to warn about high proof, and chains of bars would love to warn, hey, this new drink formula we've got, watch out, it'll really knock you out, you better only have one. And that advertising is forbidden or highly regulated because everyone knows the game that's being played. Well, will this surface in newer areas of food regulation? I believe I may have spotted an instance of this when the calorie count regulations began going in at restaurants, and of course studies were soon done saying, did these work? Did these lead to lower calorie consumption per customer? And they found that it was a mixed bag. For some demographics, it seemed to be working exactly as intended, and the people would walk out of the restaurant having had a lower calorie meal. On the other hand, for young men, it appeared that the accurate labeling of calories actually caused them to zoom in on higher calorie products. Hey, I hadn't tried that. That must be good if it's got that many calories. And they efficiently, in search of what they wanted, were walking out with higher calorie intake. Well, the fourth train wreck, I was going to use, until I changed my mind, I was going to use the legal notices in the back pages of the newspapers in which someone is having rights cut off in family law, or someone is doing something to a nonprofit board, and the law requires that in a newspaper of general circulation, you must publish a surprisingly expensive ad which no one will read. Before you can go ahead with terminating the rights or whatever. And it's not quite fair to say that no one reads it, because certain lawyers and certain agencies will comb the things, and yet were we starting it today, pretty obviously the internet would have something to do with required legal disclosures. I suppose it might start a chain of consequences that we could not fully predict to have them be searchable, and yet if the idea is to have a legal notice be disclosed, you might want it to be searchable. And this is an example of ones that may have had a very good rationale when they started, but sit forgotten as technologies change and legal needs change. And I realized I'm not going to actually use that example because I like newspapers. I make considerable money from newspapers. Legal notices are the only things keeping newspapers from going out of business. And far be it from me to criticize them. So instead I'm going to use patent false marking. And some of you in the IP courses may have seen the controversy of the last few years. 19th century law that was probably totally sensible in its day, saying that you could help protect your rights in an invention by stamping a number on it of the patent number. Perhaps, you could see intuitively how this made sense. Getting to Washington to check out a patent claim might take weeks. And yet, people needed to know whether or not they could duplicate something. So there was the main way of finding out by the stamping of a marking on it. Well, this law stood in the books for a long, long, long time after people had more or less forgotten about it, and it continued to make it illegal, punishable by $500 per, threshing machine? Per transaction, anyway, to leave either a erroneous or made-up patent number, and you can see where that would be fraud, or more interestingly, an expired patent number, and all patent numbers do expire. Leave it marked on your product. Well, next thing that happens, clever lawyers come along within the last decade or two. Notice the $500 penalty per mismarked product. Notice that, here and there are plastics manufacturers who are not changing their assembly lines just because the old patent runs out, and therefore, with plastic cups, for example, continue to have obsolete patents, and say, all right, for every, I don't know if it was Solo or Dixie or what, but for every Solo cup you've sold in the last 8 years, I would like $500 for this. They were using a Cato public attorney general sort of thesis for that. And my favorite application of that was against makers of antique reproductions, wood stoves, for example, where they're trying to create the old Vermont ambience, and they would simply exactly duplicate the 1859 wood stove down to the patent number on it. Oh, how foolish that was of them. And some of those companies got sued over old reproduction toys, musical instruments, as well as wood stoves. Well, Congress actually fixed this, a line you will probably not hear again today. Congress passed legislation that actually fixed this, but it shows again how, as times change and technologies change, people leave the warning systems in place. The last train wreck is in California, and it is Proposition 65, the toxics labeling one. It was a voter initiative, like so many other voter initiatives. It did not feel that much of a need to compromise with the community that it was regulating. It provided that you could sue and effectively collect legal fees if someone was selling something that was carcinogenic or teratogenic. Over the many, many years since then, our understanding of what is carcinogenic and teratogenic has expanded and expanded and expanded to the point where hundreds and hundreds of products have been sued, such as brass knobs which contain lead, which if you ate the brass knob might give you cancer. Roasted coffee, nearly all forms of combustion, which means the grilled chicken has been sued and roasted coffee has been sued, because sure enough, they actually do contain carcinogens. Matches, matches give off carbon dioxide, or carbon monoxide, I'm sorry. Guess what carbon monoxide is? So, to all but a small sector of the legal community, Proposition 65 has turned into a racket. It is very difficult to reform because the lawyers are making so many millions of dollars running around filing suits against innocuous products that they won't let it be reformed. And it was, if I could comment briefly on Proposition 37 in California and why it provoked such an enormous business resistance from grocers and from various others who it wasn't known whether they would be on the defense or not. One reason was that they saw similarities to Proposition 65. They saw similarities in the enforcement mechanisms. And that when they saw that, they thought, we can't let this pass, content aside. Well, I will conclude. What I've been saying is about consumer disclosures made at the time of the transaction. Please do not extend it to environmental disclosures, which I think are different. Don't extend it to disclosures to sophisticated parties, which I also think work differently. But look at area after area, and you will find very disappointing results, which makes me wonder why every time a new proposal of this sort comes up, people say, this time it will be different.
Thank you for the opportunity to speak today. For full disclosure, I'm not a lawyer. I think everybody else here and most of you either are or want to be. I don't want to be one. Some people have suggested it, and I'm much happier harvesting food when I'm not in the state senate. I actually wanted to start on a fairly somber note as I was thinking about today and wondering what to present and how to present it. And today happens to be a very personal day for me. 29 years ago today, my sister woke me up in the middle of the night because my father had passed away. He passed away from stomach cancer, and he was a doctor. And it turned out a handful of doctors all received, I actually thought, oh, this was actually a fit. But a number of doctors were using a relatively new technology. And it was a technology that included radiation in the blood vessels of their patients while they're doing heart surgery, so they could observe what was going on a screen. A number of those doctors died of stomach cancer. That's the level of where the patient is, if you think about the situation in an operating room. Now, today, doctors wear lead vests when they do this kind of surgery. The reason I think that's relevant to today and relevant to some comments that were made earlier about how regulated this is or isn't, and what studies are done or aren't done, and how the FDA does or frankly does not regulate genetically engineered products, is that right now the FDA still basically relies on the industry information and, as was stated earlier, summaries of that information. And in fact, their own disclosure statement says, we approve this based on the information that the companies have given us. They don't just approve it. They make a very clear disclosure that it is based on the information those companies have given them. And so when I think about the topic of genetic engineering, obviously we think very much about science and technology. And I think there needs to be far more study, and there's starting to be those studies and starting to be information coming out that raise questions and not necessarily causality just yet, but certainly interesting correlations between human health concerns and genetic engineering. And when it comes to drafting a law to allow consumers the right to know what's in that food, one of the legal arguments that I think will come up when this is taken to court by the seed companies and food manufacturers will be states' rights and states' interest. And fundamentally, one of the most important aspects around that is around human health. And I believe that as individuals, we have a right not to be the guinea pig if we don't want to be. And that's what food labeling comes down to. And it may be, just as the technology my father was using has led to many, many good things and many, many people's lives going far longer, maybe there are positive benefits to GMOs. But it's also critically important that we both do the adequate research from a perspective that is not from an economic gain perspective as the companies do, but from a health and environmental perspective. And we need to do that. And we need to allow for the citizens of our country, as citizens in 64 other countries that has been noted, have the right not to be part of those experiments if they choose not to be. So when I come to this discussion, I think of it both from a legal perspective and an emotional perspective. And I happen to think that both can and should be a part of the equation in many decisions that we make in government, politics, etc. Now, when I was first contacted, it was to talk about it from a farmer's perspective. So I'll take the Senate hat off and the kid whose dad died hat off, and I'll put on the farmer's perspective. Genetic engineering has radically altered the agricultural framework, as obviously many of you or all of you know. As a farmer, and as an organic farmer, I just want to point out also that GMO labeling laws will actually probably reduce the advantage I have as an organic certified farm. Because there are people today buying organic food to avoid GMOs who will actually have further options and conventional options that may be less expensive than the organic products in order to avoid GMOs, if they so choose. So I just want to point out that this is not about organic farmers gaining market share. It's actually probably going to temper that a little bit. But from a crop production perspective, there are tools that I use as an organic farmer. Natural pesticides. I don't use herbicides. Thank you. Except for our fingers killing the weeds. There are natural pesticides, particularly Bacillus thuringiensis, but others as well, that are bacteria that disrupt the digestive system of the pest that they're trying to kill. There's one for Colorado potato beetle, which right now we're no longer allowed to use because of organic standards, because the company won't disclose the inert ingredients, so by organic standards we can't use it. But there are others that are for imported cabbage worms and other larval stages of a number of creatures that we would prefer not to find in our food. And what happened, the original, besides the herbicide tolerance, the other major insert that's been genetically modified is to insert the genetic material from Bacillus thuringiensis into particularly corn, but also soybeans, so that when those pests specifically start eating the leaves of that crop, they actually start to have the digestive problem and they die. Not such a bad thing, you're trying to kill the pest. The difference is, as an organic farmer, when I apply it, I've been scouting, I apply it once I might not hit all the crops. I often use a backpack sprayer and I'll just hit certain spots, which means I'm not going to kill every bug in the field that has that predisposition to die from that pesticide. However, when you grow thousands and millions of acres of monocrops, and then you have 5 million bugs in there as well of the same world of species, they're all going to die except for a select few. It's pure Darwinism. And those select few are going to find each other and do that which many of us know how to do. And there will be more bugs that are resistant to that problem, to that pesticide. So genetic engineering is actually over time going to take away the few tools that as an organic farmer I have, which I selectively and judiciously use in food production. So in the long run, you may not have access to organic foods of certain varieties because we just won't be able to fight the pests. Think about that. So as a consumer, I believe we have a right to know and you have a right to know so you can participate in this collective decision-making process. And that it shouldn't just be a few scientists or a few regulators that are going to make that decision for you in terms of what your future food supply is going to be like. No one system is perfect or not, but you ought to have the right to make that determination. The last little story I'll tell has to do with, as an organic farmer who grows organic vegetables and organic meats, which is not very common. These disclosure laws have often exempted meats. And from an impassioned perspective, for the 2 years I was out of the legislature and they introduced this bill and it exempted animal products, I was livid. And as I look at the ads that the companies are, the opponents of 522 in Washington are airing, I think they're similar in California, they're saying dog food would be labeled, but this slab of steak would not. The issue is about direct consumption of the product. So if a cow eats genetically engineered corn, there's really, right now, no scientific evidence to show that if you eat an animal that ate a genetically engineered product, that you would have a health consequence. But if you eat direct genetically engineered product, there is starting to be evidence to show that there could be a human impact. Is it definite? No. It's not nearly as clear as, for instance, climate change, as we all know. But there is a significant building of doubt around this issue. Jeffrey Smith from the Institute for Responsible Technologies has a movie, and it shows a number of graphs that since the introduction of genetic engineering in 1996, genetically engineered corn, sorry, sweetie, I can't answer your phone call right now. Since the introduction of genetically engineered corn in 1996, the increase in gastrointestinal ailments, Crohn's disease, celiac, various allergies to many, many foods have gone up. Is it causational? We don't know yet, but it's an awfully interesting circumstance. And it's not just sort of up, it's up. And when you think about back to what that BT does, and what the scientists from the chemical companies have said, what that does is it striates and scars the digestive tract of the animal, or the bug, and it dies. They said, that'll never happen to us, our systems are much too big. Well, if you think about it, if we have minute, we're talking very small scale here, little cuts in your digestive system, the food that you eat, instead of entering your system through the normal processes where your body breaks it down into bits and pieces that your body can use, and your body takes those bits and pieces and appropriately transfers them through into your bloodstream, and then that go all over your body, and you have the sugars and the carbos and all the different vitamins and minerals that you need. If your small intestine is scarred, and some of these products go directly into your bloodstream without being broken down appropriately, your body sees them as a foreign object. What is an allergic reaction? Allergic reaction is your body attacking a foreign object that it doesn't think should be in your body. So we have all these young people who have never lived in a world without genetic engineering, who are now developing a tremendous number of allergies to a wide range of foods. Am I going to tell you that it's scientifically proven? No. But you have a right to know so that your children can avoid that risk for the time being until they know better? Yes. And I think as we make laws, as we look at legal documents, we need to consider more than just strict legal interpretations all the time. We need to look at the broader picture for our society. Thank you.
Thank you all. I think I could ask you 100 questions. But I tried to think of one that could tie together all your different perspectives. And one thing that Christine said that I think is interesting, and at least something I'd be curious to hear your perspectives on, is that not every bit of information that's useful to consumers is mandated by law. And I guess my question is, as Walter pointed out, warning systems stay the same, but our production methods are changing dramatically. So how do we draw the line and figure out what information consumers should know, and should that be changing constantly, and how do we figure out what's important for consumers to know versus what they might want to know, and how do we draw the line between the information we feel we need to provide versus allowing them to sort of self-educate themselves?
And I would say the FTC draws the line at sort of direct impact of health or safety on the consumer. And like other pieces of information people would like to know, does this manufacturer pay its employees a fair wage? Does it provide them with health insurance? I mean, there's an endless list of things consumers might want to know about the companies they deal with. And so the only situations in which we've required a disclosure up front that's not triggered by something is when the item is really not suitable for the use it's advertised for. If it has an inherent safety risk, or it's advertised for a population that has some special need that would be undermined by consuming the product.
I mean, I think that's a complicated question, and it, in some respects, it depends. The answer depends on who's answering it. So, if one of my clients who makes a consumer product is answering that question, they may use market research to determine whether or not a consumer finds something to be relevant or not, and make the decision based on that. A regulator may use another basis to make that decision. We're seeing increasingly gluten-free labeling. There's new rules out from the FDA on it that pertain to most foods and some other products. But is gluten-free relevant to people who want to avoid gluten when they're purchasing soaps that may have or baby baths? A baby can drink the water in the bath. If it has gluten in it, it's digesting it. So, I really think that being careful about who makes that decision is important to consider.
So I'll give a lawyerly answer, I guess you would say. With regards to the federal government, I think that on the FDA side, as opposed to the FTC, specific to, for example, genetically engineered crops, it's a determination of what's material or what's not material. So as I mentioned earlier, they're basing that determination still off of a policy that they made in 1992. So in addition to the work on a state level, we've petitioned in 2011. We filed essentially a legal blueprint with FDA saying, hey, look, you're allowing these labels to go forward in a misleading way. Because this is material, and you're basing this on an arcane legal interpretation that's forgetting or refusing to recognize the fact that we've had 20 years of these new, food production technologies, and you need to update that. So we think everybody should have that, and it is a material determination, but that is the legal basis in the Federal Food, Drug, and Cosmetic Act. I think for both the federal government and the state level, one of the other, I think, determining factors is what we discussed with regards to whether there's a legitimate interest. But I don't think it's limited to just whether it's safe or not. I think there can be many legitimate interests, as I mentioned, and that's kind of what the limits of the First Amendment are, that we can impinge on commercial manufacturers. But I think what's important is that here, when you talk about factual disclosure, that can be a deciding factor. When you talk about what might be misleading if it's not on there, then maybe that's something that we should look at, and courts do look at that. So, for example, I would argue the absence of labeling something is genetically engineered is actually in and of itself an omission that is misleading, because it is without question genetically engineered, whether you want to say what that means or not. And finally, international norms, and we talked about that a little bit. I think we can look to there, as we have in other areas, as a society, to make those decisions.
In the absence of regulation, the market will already call forth a lot of disclosure and a lot of claiming, and the question is whether prescription from the government will do a better job than is already sometimes an abundant amount of disclosure and claiming that's going on. Now, I doubt when the market has not called forth a lot of labeling on something like GMO, it causes me to doubt whether consumers are actually as interested in that as they are in gluten, fat, salt, and a bunch of other things that we know they are very interested in. But I'll leave you with the thought that for both privately arranged labeling systems and publicly, there may well be a desirable goal of standardization, particularly when you see a lot of sellers trying to make kinds of disclosures, but each doing so in its own way because of history or whatever. There may be group gains to be had for both producers and consumers by giving them something like nutrition facts, which provides a standardized format.
Well, I guess there's a couple triggers here for me. One is, in agriculture, this is such a radical change in our food system that to me would warrant it. It's not like this is some tweak of a modified pesticide or a modified herbicide that we've been using for a long time, and the industry has tweaked it a little bit for EPA reasons or whatever, and it's improving its environmental efficacy. So I think when we see radical changes in any field, but particularly in the fundamental field of what we eat, that it would warrant it. I would say in general, historically, we have had a trust in our government regulatory system. I would also say if there's a new system or a new technology, well, government has reviewed if it's environmentally or health-wise okay to use. But I guess I would ask the question, should we, given the incredible power that corporations have with respect to our elected system and full disclosure, I'm in elected office at the moment. I don't accept any corporate contributions, but when you look at Washington, the amount of money that's needed to be raised, whether you be a Democrat or a Republican, full disclosure, I'm a progressive / Democrat in Vermont, the amount of money it takes inherently makes that whole world skewed. You just can't run for the US Senate, certainly, and pretty much the US House without so much money that you have to take those corporate donations one way or another. And earlier I asked a Tea Party question about faith in government, and I think that's where I was trying to aim earlier with my question was, the distrust of government should really be a distrust of corporations, and at this point the two have become so interlinked that's why I felt there is actually an avenue for discourse with some people in the Tea Party who are just angry and they're about the system. And lastly, I would say, in terms of the issue of GMO specifically, gluten-free and other things have been market-driven. To actually make a claim of GMO-free is actually quite expensive, just proposition, because you have to continually test your product for something that is continually evolving, and genetic testing is not an inexpensive process. So putting the onus on the people that aren't using something to make them pay extra money to tell you they're not using it, which has been a common argument. Why don't we just do GMO-free labeling? That I just think is ridiculous. And maybe that's not a very cogent legal argument. That's ridiculous. But that's what I think it feels. And the last thing is, there have been a lot of labels used to try to appeal to a consumer base that's actually growing very, very fast. Much to, I don't know if it's Walter's chagrin or not, but at lunch you mentioned how things that happen in Vermont seem to keep creeping out into the rest of the country. And so, Fair enough. And words like natural and pastured and all sorts of other words are being used, ethically raised, to define our food system. And none of these words have definitions under, as far as I know, state or federal law. And many people don't even realize that a pastured pig or a pastured chicken, for instance, are still, in most cases, hugely grain augmented. So when I sell, I'll give you my farmer experience, I sell organic chickens at the farmer's market. Most people think that all the eggs and all the chickens and all the pork that are at the farmer's market are organic, partly because they're local, and local means organic, which it doesn't, and partly because they're pastured. And people think, oh, they're out grazing. So they're eating grass and bugs, how wonderful. Well, you're not producing an egg a day out of a pastured chicken unless they're getting a lot of grain. You're not raising chickens for meat in 8 or 10 weeks over the summer if it's not getting augmented with a lot of grain. And so I would say the consumer is demanding it, but they're actually not getting it because they're being fooled by other marketing that's out there. And that's why we need disclosures so that we don't continue to deceive the customer, I believe, as the FTC would like us to.
Can I just jump? Just a concept that I think is worth throwing out there is, this, when you're considering about disclosures, particularly from food and consumer product perspective, is a label is really small. And as judicious as we know David is with his herbicides, a marketer needs to be especially judicious with their claims because there's just not that much room. And in fact, how marketers are increasingly communicating with consumers, the space for that communication is shrinking. If you're on your cell phone and you're trying to get information about a product, and the marketer also has to do a slew of disclosures, there's just not that much real estate there to get everything across in an effective way to inform the consumer of everything they need to know. And so, I think we do have in our mind this concept, as Walter was explaining, of unfolding the disclosures that come with your medication. But I think now and increasingly in the future, it's not going to be that. It's going to be tapping away, trying to figure out what the answer is.
Great. Well, thank you so much.